My name is Addison Caruso, and I'm an Ohio staff attorney with Fairshake Environmental Legal Services. Here are some things you should know before you sign a lease for Pore or storage space to store carbon dioxide underground for carbon capture and storage. Fairshake Environmental Legal Services is a nonprofit law firm that represents clients of all income levels on environmental and energy justice matters. We are dedicated to the idea of community and client-centric representation and believe in empowering communities and individuals we work with. We provide services on a pro bono and sliding scale to both individuals and organizations and focus on traditionally underserved clients who are directly affected by environmental harms. We have many wonderful non-attorneys on our staff too, who provide support, resources, and assistance to communities and assist them in building people power. We also have a robust internship program where we aim to educate young attorneys and law students to better understand how they can serve underserved communities. As a disclaimer, the material in this presentation is designed for general informational purposes only, and the information contained should not be construed to be legal advice or to signify the formation of a lawyer-client relationship. If you have any additional questions or need more information, please consult an attorney. What is pore space? Pore space is the empty space between particles of sand and sediment, or the space within and between rocks. We would inject carbon dioxide theoretically into the ground to fill these spaces. Pore space is oftentimes created once oil or gas has been extracted from underground by an oil or gas company. This part of the country, Eastern Ohio, West Virginia, and Western Pennsylvania, has been identified as having the right geology to store carbon. That means in our region, there'll be many companies looking to lease pore space to store carbon dioxide underground. Generally, in a contract for pore space, it is an agreement between that would lease the surface and subsurface rights need to build a carbon capture and sequestration system that stores the carbon dioxide in a geological formation below a landowner's property. These agreements generally convey a few things. They convey the length of time, which determines how long the lease will be in place and whether it is for a fixed term or not. During the term of the lease, the landowner may or may not be able to use the property for other purposes or terminate the lease early. It also includes carbon dioxide storage rights, which include the exclusive rights to store carbon in a reservoir area, which is often located thousands of feet below the surface. These contracts generally convey surface rights as well, which are the rights to use the surface area to construct and install the carbon capture and sequestration system. This can include things like an injection well, storage facility, pumping, or any other facility that is needed. The size of this facility can vary and can potentially include surface rights for a pipeline or transportation to service the sequestration system. Surface access rights are the right to access the property to construct, install, operate, and maintain the carbon capture and sequestration systems over the life of the project. Generally, landowners will retain the right to access or use their property for any purpose, as long as it does not interfere with the carbon capture and sequestration system or the company's storage rights. This surface access can be in the form of an easement, and generally surface rights are leased because the company that is storing carbon dioxide needs space for installation, maintenance, and operation of pipelines, meters, and other equipment that will transport the carbon dioxide from its source. Payment is often included in a contract as well, and typically this payment will be through a lease bonus, an annual rental fee, and or a royalty payment based on how much carbon dioxide is sequestered underground. Each contract is unique and different, and these are just general terms, and you should read the language of the contract and see exactly what you are agreeing to before you sign anything. Some red flags that you should be on the lookout for in a potential pore space contract are an indemnity clause and whether that is in there. An indemnity clause may allow the company to reimburse you for any damages, leaks, or property damage carbon capture and storage causes. If there's no indemnity clause, you may be on the hook for any damages that are caused. Broad sweeping terms that are unclear and may put the liability on you depending on what happened. One-sided provisions you should be on the lookout for. These are terms that where you might be stuck with liability if something bad were to happen. Low value offers that undervalue the price of your land and lowball you. High pressure tactics. If someone comes in and says you have 10 minutes to decide or says they're walking out of the door if you don't agree, you should take your time before agreeing to any contract. And if anyone is trying to put you in a high pressure situation, that should be a red flag. A lack of surface protections. Carbon capture and storage requires pipelines and truck to maintain the system. And if the company has no responsibility to fix it, that could fall on you as a landowner. You should finally be on the lookout for buried add-ons. These are terms in the fine print that can be easy to miss, so you should make sure to read the contract carefully and thoroughly before you sign it. When presented with a contract, you do have the opportunity to negotiate with the carbon capture and storage company. When negotiating, you should make sure to take your time. There's no rush, and if they're trying to put an artificial deadline on you, that should be a red flag, and maybe it is not the best decision for you and your family. Consider talking to an attorney before signing anything and have them look over the language of the contract. Oftentimes, these contracts contain complex language and legalese that may be meant to confuse the landowner. Consulting an attorney will allow you to understand what is exactly located in the contract and allow you to better make the decision for yourself. And make the decision that is best for you and your land. You should not feel pressured into anything, and ultimately, you need to make the decision that is best for you and your financial situation and your family. If you have any questions, please get in touch with us at our phone number, our general email, check out our website, or get in touch with us on social media. Thank you very much.